Good evening. Good evening, everybody, and welcome to another installment of the Safe Family Recovery webinar series. My name is Jim Derrick. I'm a co-founder here at the Safe Coalition and also the director of Family Recovery. And before we start this evening, I thought I'd just take a quick minute and review what family recovery is and how you might be able to access the resources here at Safe. So, family recovery is a process by which the family unit heals and individuals within the family unit heal from the impact of living with someone who is coping with substance misuse or a mental health diagnosis. Families are impacted dramatically anytime that mental health issues or substance misuse are present in a family. And that's why we call it a family illness. And so we know that the family needs its treatment just as much as the loved one needs their treatment to get on their path of recovery. We do that here at SAFE in a number of different ways. A few of those ways we provide one-on-one peer support from people that have walked this walk before and are happy to companion people as they start their recovery process. We have clinical care here at SAFE, so you can meet with therapists. And we also have a variety of support groups. One in particular is called Families Anonymous, which meets here every Tuesday evening from 6:30 to 8 o'clock. It's a 12-step program, much like Al-Anon, except that it incorporates mental illness as well as substance use disorder as a qualifier for people to come in. So that's for people who have loved ones that are struggling with either of those disorders, and you're welcome to come in. Please contact us at 508-488-8105 or drop me an email should you have any questions or should you want to access our services. Of course, Friday mornings from 8:30 to noon, we are open with no appointment necessary. You can always come in. There's hot coffee. It's like living room-like setting here, and you're welcome to join us for some casual conversation and maybe to find out about our resources and see whether or not you or someone you love might be helped by some of the things that we offer here. And finally, I will let you know that all of our services are free of charge to the public. So with that said, thank you again for attending. I am absolutely delighted to be bringing this presentation to you tonight with Michelle Kelley, who I met many years ago at really the formation of SAFE. Michelle then was the clerk magistrate here at Rentham Courts. And I was someone who, maybe like many listening, had a son who was struggling with substance use disorder. And Michelle was my first contact at the courts, and she demystified the entire court process, provided incredible service to not only myself, but to other constituents that came to her through SAFE and many in the community, and demystified the entire court process. And most importantly, taught me and taught our community that the court was there to help. And it was a place, it was a resource that could actually help. And that resource was meted out by people like Michelle, who actually cared and had an incredible heart for this business. I'm thrilled that Michelle agreed to join us tonight. And so without any further ado, I introduce the Honorable Michelle Kelley. Thank you, Michelle.
Okay, hello, everybody. It's my pleasure to be here, Jim. Thank you for inviting me. It's as in my new role as a district court judge, I rarely have an opportunity to talk with people about what the courts do, because we, in our positions in the court, we can't give advice. So it's very challenging to talk to people or try to help people. So I'm really grateful for this opportunity to kind of share what the court does. I'm glad that it's being recorded so that folks can access it if they need help in the future and couldn't make it tonight. It will be a great resource, hopefully, that they can go to. So I'm going to just ask Jim, can I begin my presentation at this time?
Yes.
Okay, so hopefully everyone can see these slides as I go through. And again, my goal this evening is just to tell you a little bit about what courts can do to help an individual or a family if they are in crisis mode. So it's important for everyone to know that, the courts do more than just the crimes and punishments. And when we drive by a court, we never think that it's a place where we can go for help. We hope to never have to go there unless we're serving jury duty. But in fact, there are a lot of resources in the district court that most people don't know about that can help people with substance use, alcohol use disorders, or even mental health crisis situations. So I'm going to kind of talk about the different landscapes. So I'd like to call part one the emergency landscape. And that is all governed by Mass General Law, Chapter 123. And in the district courts, we do have Section 12s. I did put 12E there because there are differences between 12E and other sections of Section 12. And I did that just in case, again, people were reading this after the presentation and need them to understand that a 12E is done in the court. A 12A, which is often referred to as a pink paper, that's because of the color paper that it previously was printed on. That is done in a hospital setting, often through a 911 call. I'm going to touch a little bit on both of those, the Section 12s, but I am going to pay particular attention to the E, which is what you would go to the court for. And that is an emergency commitment to a mental health facility. Section 35, that's a civil commitment, and that is for alcohol and substance use disorder. And again, that's when you are coming to the court to try to get someone involuntarily sectioned. It's what it's called, which would be it's an arrest, and they get evaluated at the court. They are arrested and transported to the court, and we'll get into a lot more detail regarding that. But it is important to understand that that's the emergency landscape, and that is when you really need help and you need it immediately. And then part two, I'm going to discuss some recovery court information, and that is where the court focus shifts from incarceration and punishment to intensive clinical rehabilitation. And recovery courts, we do not have one in the Rentham District Court at this time. I'm really hoping that a day will come soon when we will have a recovery court in Rentham. The nearest recovery court for us in our county is Quincy, which is frankly, a little bit too far away for most folks to really get involved in, but it is available to anyone who may have a case in the Rentham District Court. They can go to the Quincy Recovery Court. So again, the emergency landscape, I will say this first. If you are in an immediate crisis, what I'm going to discuss tonight is probably not what you should do. You should call 911. So that is something that's important. I do want to make sure everyone understands that you are going to a court when you're utilizing one of these resources, and it is timely. So it's not something that you show up to the court and things happen immediately. It does vary court to court how quickly your case would be heard. Both a Section 12 and a Section 35 are both priority cases. So the court is supposed to make that a priority case, call that over any criminal case, any civil case, any other case aside from a restraining order, that it is a priority case. So a Chapter 123 petition and restraining orders are the priority cases that take priority over all other case types. But it is the timeline it's not immediate. So your immediate care and protection is always by calling 911. So let's talk about the two different pathways of emergency commitments that are available to individuals and families in the court system. So the first one, again, is Mass General Law, Chapter 123, Section 12. So you commonly hear these called like Section 12, or I have sectioned my son previously. That's either a Section 12 or a Section 35. Many people just call them a section. And again, what you want to think about is an involuntary commitment for both of these. These are involuntary commitments. So if you have a family member who needs help, and whether it's mental help for mental stability issues or psychiatric issues or alcohol and substance use disorders, there are two different avenues. And the Section 12 is an emergency commitment to a mental health facility. Any person can come to the court to file a petition. If you research this online, it may say that it has to be a physician, a nurse, a psychologist. that is, when you see that that's not accurate, they're referring to the application for the 12. So they're referring to the actual commitment that does have to be, that application has to be completed by a specific type of person. Again, most of the time it's a physician, a nurse, a police officer, or a psychologist, or any type of doctor in an emergency room. But we're talking now about 12E. So that's why I did want to put that E on there. So we're talking about when you come to the court, any person can file a petition. In both of these cases, you go to the clerk's office at your local district court. You also can go to a juvenile court if the person who you are concerned about is a juvenile, and that would be under 18. You would go to a juvenile court. You can go to the adult court, but it's very likely that they're going to send you to the juvenile court, or they'll try to get a juvenile judge. But it's really not the appropriate jurisdiction. You should go to a juvenile court if it's someone under 18. You fill out a petition. So the petitions are, most of the time the petition is one page, but then you usually will do an intake where you give information to the court about what brought you there. So what is the basis? A person has to be suffering from a mental illness, and the standard is that failure to hospitalize this person would result in a likelihood of serious harm by reason of mental illness. And the commitment for that cannot exceed 3 days. And again, I'm going to get into more detail about each of these. So for a Section 35, this is when you are in a crisis mode where you feel that your loved one is suffering from alcohol or substance use disorder, and you feel that failure to commit them would result in serious harm to themselves or others. And as far as this goes, it's not any person. It is a very strict list of who can petition for a Section 35, and it has to be only a blood relative. I'm going to stop here for one moment and just emphasize the blood relative portion of this. If you're a stepfather or a stepmother, or a stepsister, stepbrother, you are not a blood relative. Section 35 does not recognize, by blood or marriage. It is a blood relative. So unfortunately, we have had situations in the courts where a stepfather or a stepmother will come in for their stepson or stepdaughter, and they don't qualify. So we wouldn't be able to put that petition before a judge. They would have to get someone, which they usually do. They usually call someone, and a blood relative will come to the court and fill out the petition. So again, blood relative, spouse, guardian, a court official. So we do have probation officers who will file Section 35 for people who they're concerned about. And we often have police coming in. I can tell you that Franklin has a pretty aggressive history of filing Section 35s on people in the community who they're concerned about. And I can say also Walpole, as far as the Rentham District Court, I've seen numerous petitions from those two locations, or a physician. And there is case law that says that a physician, that also does include a nurse. So even though the statute still only says physician, there is case law that says that could be a nurse as well. And again, the person is suffering from an alcohol or a substance use disorder. Failure to commit the person would result in serious harm to others. And that commitment is to a treatment facility not to exceed 90 days. So the first steps of filing both a 12E or a 35, again, you go to the nearest court, district court, BMC, or juvenile court. You go to the clerk. You go to the clerk's office first and ask for the paperwork. You fill out the paperwork, and then they will tell you to go into the courtroom. Sometimes they'll walk you into the courtroom. It is important to know that this is not an anonymous procedure. This is not a closed file necessarily. So you do have to go into the courtroom and speak with the judge about the reasons for the petition. So you'll be sworn in, and the judge will read the petition and then say, what brings you here today? What are your concerns? And you have to go on the record with sworn testimony indicating what you're concerned about. If allowed, the judge will usually ask you, so based on what I've read, is it accurate to say that your son will not respond to a summons? And generally they say, no, absolutely not. And a summons would be the court mails a summons or has it served on your loved one, and it gives a court date. Most of the time, I can tell you, I've been in the court system since 1995. I think I've seen 2 summonses issue. Every other Section 35 that I have seen has been a warrant. And again, generally the family is in a crisis mode at this point, and a summons is not what they're looking for. They're looking for immediate, care and commitment. So more than 90% of the time, it is a warrant that issues. It's called a warrant of apprehension. And that's important because the respondent is arrested only during court hours. So the warrant of apprehension is not good at night or on weekends. It can only be used by the police during court hours. And the local police where the person is located, the person is called a respondent. So you may hear me say the respondent, that is the loved one, the person who you're concerned about. That person is located. Even if they're outside of the jurisdiction of the court where you filed the petition, and you find out that they're now in Norwood, you would call the court and say, I just heard from his girlfriend that he's in Norwood. So then the court would contact the Norwood police, and the court would give the Norwood police an indication of where in Norwood the person is, and then it's likely that your loved one would be brought to the Dedham District Court in that scenario, the court that services the location where the individual is located. It's important to note that the local police cannot hold a person in a police station on a warrant of apprehension. They can only apprehend the person and bring them directly to the local courthouse. They do not go to the police station. They do not stay overnight. When they arrive at the courthouse, on both the Section 12 and a 35, a lawyer is appointed and a clinician is contacted to begin with an evaluation of the individual. So a Section 12, and again, 12E, so this is when someone has a mental illness. So this is when you are seeing behavior from your loved one that is concerning. And the statute defines the mental illness as a substantial disorder of thought, mood, perception, orientation, or memory which grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life. It's important to understand this does not include someone with intellectual or developmental disabilities, autism spectrum disorder, traumatic brain injury, psychiatric or behavioral disorder, or a symptom due to another medical condition. So this is someone who is suffering from a mental illness that is causing you to be concerned about their safety, or they may be in harm, or they may harm someone else due to their mental illness. It does not include alcohol or substance use disorders unless these conditions coexist with a mental illness. So that's important to understand, that a Section 12 is not going to get you to a detox or treatment facility. It's going to get you to a psychiatric facility. They will also treat any alcohol or substance use disorder, but the primary focus is the mental illness. And the standard that is looked at is based on competent medical testimony after evaluation. The court finds that failure to hospitalize would result in a likelihood of serious harm by reason of mental illness. So that's what a judge has to evaluate. Again, doctor is called, lawyer is appointed. You as the petitioner have a right to be there. You don't have to be there. The person can still be committed even if you went back to work or you don't want to be there. I will say with both of these sections, it is difficult at times because your loved one is in a dock with often sitting next to criminal defendants. And sometimes it's really hard for people to see. So it is important to understand that before you do either a Section 12 or a Section 35, that your loved one is in fact taken into custody. They're in handcuffs by the police, taken out of your home or wherever they are, and they're brought to the lockup at the courthouse. If they are not medically stable, they'll be brought right to an emergency room. We cannot take anyone on a Section 12 or 35 if they cannot safely be held in the courthouse lockup. So we'll almost always bring them directly to the police. Will bring them, or an ambulance will be called. So when the doctor will make a recommendation and find a bed after when the commitment is ordered. And oftentimes the Section 12E from the court the court ends up contacting our local police, and then they fill out a Section 12A. And most of the time, the individual is brought to the local emergency room, and that is where the commitment takes place. So that's something that's important to remember as well. And sometimes if you filled out a 12E and the police get to your home and the respondent, the person, the individual who you're concerned about is, I would just say out of control, may potentially could be harmful, could be dangerous, or just is simply not coherent, the police can make a determination to go directly to the emergency room. And at that point, your 12E becomes a 12A. And the emergency room will do the exact same Section 12 commitment. It's just under a different statute, but it is the same standard, the same commitment, the same amount of time. And that commitment cannot exceed 3 days. And then if a further commitment is needed, that is done through what's called a Section 7 and a Section 8. So now we'll turn to the Section 35 petition process. Very much like the Section 12, you file the petition. Again, blood relative, spouse, guardian, police officer, court official, or doctor files the petition and the affidavit. And then you go into the courtroom. Again, the process is the same for the Section 12 and the Section 35. The judge reviews it, and then the judge makes a determination that a warrant is necessary and the standard has been met. The warrant issues, the police bring your loved one to the court. Again, an attorney is appointed, a clinician is contacted. One distinction between a Section 12 and a Section 35 is for a Section 12, it does require a psychologist. It does require a doctor, and a Section 35 evaluation can be done by a licensed social worker. So we do have a lot more success getting the Section 35s processed faster in the courthouse because we can call our clinician, and it does not have to be a psychologist. It can be a licensed social worker. So the court clinician will talk to the petitioner, will talk to the respondent, will talk to the individual in custody with the lawyer, and will then present evidence to the judge in its sworn medical testimony. And then the judge will make findings. And if the commitment is ordered, it is a commitment up to 90 days. However, on a Section 35, it's generally under 30. The actual commitment is generally under 30-day commitment. So meaning they're released, they can stay up to 90 days, but generally it's 22 to 30 days is usually the time period where they're detoxed and they're also given treatment and released approximately 22 to 30 days into the commitment. So for the Section 35, there's the preliminary hearing that we talked about, which is when you go before the judge and the judge determines whether there's a basis to issue the summons or the warrant. And all that the judge has to find is that there's a reason to believe that this person has an alcohol or substance use disorder. What's the definition of that? It's the chronic or habitual use of alcohol, controlled substances. Recently, it has been added that it's intentional inhalation of toxic vapors. That was previously not part of a Section 35, and it has been added over the last couple of years. And it's to the extent that it substantially injures their health, social or economic functioning, or they have lost the power of self-control over their alcohol or substance use. So that's the definition of what the judge has to find in determining whether there's an alcohol or substance use disorder. And then once the person is brought into court, there's a full hearing, again, where the clinician testifies and the lawyer is representing the respondent. And the court has to find by clear and convincing evidence and on competent medical testimony that the respondent has a substance or alcohol use disorder, and there is a likelihood of imminent serious harm to themselves or to others. And the judge also has to make a finding that there are no appropriate, less restrictive alternatives. So this is a time when someone may say, Judge, the family did find a bed at Gosnold, and they're holding a bed for this person. They have private insurance. So the doctor might say, I do think that is an appropriate, less restrictive alternative to this Section 35 commitment. So if I hear that from a doctor, and if if the respondent's family is in the courtroom and they indicate that they are going to take the respondent directly to Gosnell's or where the bed is, and I believe that that person is going to go voluntarily, then I would not order the commitment, because I would make a finding that there is an appropriate, less restrictive alternative, and that is a requirement under the statute. And in that case, I would not order the commitment. Now, I am going to just say there are times when someone will suggest Gosnell or other locations, and I'll also have evidence before me that I had a case recently where the person was brought to a less restrictive alternative the day before and did not get out of the car, would not go in, only went there because the family said, if you don't get help voluntarily, I'm going to court and getting a warrant for you. And for that reason, the person got in the car the day before, but did not go into the treatment center and was drinking alcohol that night. So the family came in the next day. And under those facts, I did make a finding that there are no appropriate, less restrictive alternatives. And in that section of the finding, I did write, respondent was driven to a treatment center where a bed was waiting, would not go in, and used alcohol that night, like last night. In this case, it was that night before. So every case is fluid. Every case is different. The standard doesn't change. And again, I'm giving you just a kind of a short summary of what all of these sections mean, but that standard is often difficult to reach. And I bring that up because there are many times when, in my former life as a clerk magistrate, I would assist, as Jim said, I would assist folks at the counter or in the lobby of the courthouse when they would come in and they're distraught and their loved one is using, and they're afraid they're gonna overdose and they're gonna die and they need help. And it sounds absolutely like a Section 35 is appropriate. We assist them with the paperwork. Everything goes well. The judge issues the warrant. The person is brought into court. And it could just be that on this particular day, perhaps, mother or father hasn't seen the respondent for 2 days or 3 days. The person is not using, appears sober, can communicate, can talk to the lawyer, can talk to the doctor. And a judge may hear evidence from the doctor that there is not a likelihood of imminent serious harm to themselves or others at that time. So then that person is not getting, the judge may not order that commitment. And that's when it's really difficult for the family, because it is kind of a timing thing where if the person does appear in court at a time when, after evaluation, they do not meet the standard, the judge cannot commit that person if the judge cannot make that finding that there is a likelihood of imminent. And that word imminent and that word serious, those are two words that I stare at many times when I have someone before me and I'm wondering if they meet the standard. And again, it's very important for families to understand that if you're in this unfortunate situation where you have to file a Section 35 and it's denied, it very likely is because the judge cannot find that there is a likelihood of imminent serious harm to themselves or others. And again, that's just because the judge has to go on the information that's before them. And it's, again, one of the hardest things that I see, that I have seen as a clerk, and I see a little bit more as a judge. It's very difficult to tell people the commitment is not getting ordered, because then your loved one is in a lockup. And pardon the expression, but they are pissed off at you many times because you just got them arrested and brought them into a court. And now the judge is not ordering the commitment. They're going out a back door and they're furious with you. So you come to the courthouse thinking that things are going to go well, and they don't. And I hate to be negative, but this is reality and this does happen. And if anyone does ever find themselves in that position, it is important to understand that the judge is following the law, which the judge has to do. And many times this happens, and the person is brought in a week later on a brand new Section 35 and is committed. because the standard is met at that particular day. So the judge can only take the facts and circumstances that are given to them through the competent medical testimony, the petition. The judge does review everything before them in making that finding. So sorry to spend so much time on that, but it really is critically important. And it's important that everyone understands what that standard is. And it's a legal standard. The judge can feel terrible and can know that that person may need help and may absolutely have an alcohol or substance use disorder and need help. But when they apply that standard of imminent serious harm to himself or others, it's not met, and the judge cannot order the commitment. So if the commitment is ordered, it is up to 90 days. Again, as I said, usually shorter, 30 days. Right now, there are 14 facilities where someone can be committed. And if they are committed, it's important to understand the respondent may not be issued an FID or license to carry once they have a commitment, either a 12 or a 35. And they can request relief from that disqualification, but only after 5 years since the commitment. So comparing Section 12E and Section 35, again, the primary focus of a Section 12 is an acute mental health emergency. The Section 35 is chronic dangerous alcohol or drug use disorder. The initial petition is filed by, again, a Section 12. Anyone can file it. Section 35, spouse, blood relative, guardian, police, doctors, court officials is actually missing from that section. The hold duration for a Section 12 is up to 3 business days for the initial assessment. But again, if the person needs further care and treatment, the facility will file a Section 7 or 8, and that is filed in the geographic location of the facility. So that's filed in another court, and a judge sitting in that court will hear that petition. And that can be 6 months to a 1-year commitment. And again, at any time, these 7 and 8, they can be changed. The person can be released. So it doesn't mean that it's an absolute commitment for the 6-month or 12-month period, but that is what can happen after a Section 12. The Section 35 is only up to 90 days. It cannot be extended. And that is inpatient clinical treatment. Generally, the facility will give the respondent a plan, an after plan. The court is notified every time someone is released from the Section 35 commitment. You as the family, you as the petitioner, you are not notified. So the only way that you would be notified is through your loved one, or you can call the court and you can say, I'm just checking to see if my son, daughter was released. And the court does have notification. It comes through in email and fax from every facility. And it simply says the day they were released and who they were released to. So the typical facility for Section 12, it's a mental health public or private facility. For Section 35, it's a designated detox and treatment center. And again, right now, I believe as of 2026, there are 14 locations. So I will now just talk briefly. I'll talk a little bit more. Hopefully there may be some questions about the Section 35 at the end, but I want to make sure I cover the recovery courts. So a couple of things about the criminal side of the court. So we just talked about civil commitments. So now I'm just going to take a few moments to talk about the criminal side. It's not uncommon for someone who is suffering from an alcohol or substance use disorder, or someone who's suffering from a mental health disorder. And it's very common that all of those exist at the same time. So it's not uncommon for there to be a dual diagnosis where someone has mental health issues. They may have had childhood trauma, adult trauma, and they may have substance or alcohol use disorder. It's very common for someone to have all of that. And unfortunately, often the result is they find themselves in criminal court. So the recovery courts it was called the drug courts, and there is a kinder and gentler title now of recovery courts. So when you hear the word recovery courts, that is only the court for an alcohol or substance use disorder. There also are mental health courts. There are veteran courts. There are homeless courts. There are a lot of specialty courts. The newest thing is a young emerging adult court specialty, and that is for individuals of a certain age, and they get, again, very much like the recovery court, they get individual care from the courts, as opposed to the normal course of court sessions and again, a finding on your case, and again, punishment of probation, jail, fines, court costs. So the recovery courts it's a way that the focus is shifted from incarceration and punishment to what we kind of refer to as an intensive clinical rehabilitation, restorative personal growth, and compassionate accountability. So a summary of this, there's so much more involved, but frankly, just not enough time to get into how the recovery courts really work. So as a summary, you cannot go into recovery court unless your case is closed. So you have to be on probation. You have to be on active probation. And how do you get into recovery court? You can say, I want to go to recovery court, but that doesn't mean that you're going to be accepted. You can be referred to recovery court from a probation officer, a judge can do a referral, a lawyer can do a referral. Many times someone is referred to recovery court when they really are at a bad place. They may be facing a sentence being placed in effect because they violated the terms of their probation. Or perhaps someone in the court sees that this person needs intensive attention and intensive assistance. And someone might say, I do feel like we need to refer this person to recovery court. So it is a team collaboration. And what that means is the judge, the defense attorney, the DA, and treatment professionals all coordinate as one supportive, unified care network. And that is not, for anyone who's been in a criminal court, that is absolutely not what a criminal court session is generally like. So the recovery courts are often small. They're in a separate courtroom. They meet generally once a week in every location. There is one judge assigned to the recovery court in each place. So in Quincy, there is one judge assigned to recovery court, and I say Quincy because that is our Norfolk County recovery court. So what happens is the team meets generally in the morning before the session. And the judge gets an update on where each person stands. Like, this person is doing great. This is what happened this week. Some people are in treatment programs, so they'll join by Zoom. They'll join the recovery court session by Zoom, and it is intensive. It is absolutely an intensive treatment that they're getting. And again, many times the first phase of your recovery court is that you're placed in a treatment program. For the accountability phase, the participants agree to regular urine screens. They agree to clinical appointments. They agree to find stable housing, which the courts assist them with. And again, the recurring status reviews are directly with the same judge, and that is once a week. And then there is supportive reintegration. And again, that's towards the end. And that is the process that will actively emphasize job training, family relationships, healing, mental health stabilization, and long-term relapse prevention. So I don't preside over a recovery court. I hope someday to have a recovery court in Rentham District Court. I think that we do have a population that could really gain from a recovery court. Some recovery courts have a lot of participants. Some have, just 4 participants, 7 participants. It doesn't matter. What matters is that the courts are capturing those folks who are ready to face this and ready to take the hard steps that are necessary to, have long-term recovery. And again, they're handpicked for the recovery court, and there are different steps of recovery court. I was recently in a recovery court, just observing one of my colleagues, and it was a gentleman who they said, "Hey, how is your week been? I heard you had a great week." And this person was, saying, "I'm having a real hard time because I distanced myself from all of my friends because they were all using, and I'm now lonely. I'm not working. I'm lonely. I don't have anywhere to go." And the judge said to probation, let's get him a gym membership. So they'll find a place near where he lives. Let's get him some job. Let's talk to him about what do you want to do? What do you like? What would you want to do for work? So they actually are helping this person. They even get movie passes. The recovery court, it is funded. There is some funding that comes from the trial court to the recovery court, but each person is treated as an individual. And what I've seen and I've been really impressed by is the camaraderie that exists between the participants of any number. I've sat in the Brockton Recovery Court, which is an incredible recovery court. They have a community justice support center in Brockton that works with them, Quincy as well. That's really helpful when you have a community justice support center near the recovery court. But it's really something to see the camaraderie between the people, and just, you really see that they're working hard. And again, many times you see a relapse as well, and you see how the court treats it. I'm going to move on because I could speak about this for a long time. So what is the impact of what we call therapeutic justice? This has been done in not only Massachusetts, but many states are using what we call specialty courts. And it does break the cycle of addiction. There's a 70% recidivism reduction. And that's not, that is an actual number that's not Massachusetts number, but that is, generally speaking, when you look at the recovery courts that are in the country, that's generally what you're looking at. And it's again, recovery and drug specialty courts that provide deep, lasting alternatives to the standard punitive criminal legal sentencing. And it's by combining strict judicial supervision with structured local clinical treatment. Participants do remain engaged in therapeutic programs, and they have much longer, the hope is that there's a longer pathway to recovery and community and family stability. And, families come in, you do see that someone who may not have had any visitation with his children slowly gets that back and shares that with the recovery court group. So it's very impactful. So this, just to kind of end our presentation, in the midst of a family crisis, understanding the distinction between therapeutic support and immediate physical safety is a crucial first step towards long-term stabilization. I will just share with you that it's not uncommon for me to, in my job as a clerk magistrate, to have helped people. And in helping them, I would learn that this is their 8th Section 35 for their son, daughter, loved one. I had someone who was in recovery who came back to the court to say hello to us. They succeeded with long-term recovery after their 13th 35 petition. And I said, what happened? And it just something just worked. No way of understanding. Everyone's road to recovery is different. Jim and the folks at SAFE can certainly tell you more about that. But never be discouraged if you do have to come back numerous times to the court. That's why we have these sections. That's why the courts are here to help you when you're in this crisis situation where you are worried about the immediate physical safety of your loved one or your family or yourself. And I will just end by saying that what I tell people when I was a clerk, unfortunately I don't get to talk too much to folks in my role as a judge, but when I was a clerk, I would say, it's very hard to watch your son, daughter, loved one leave the courtroom they're handcuffed, they're in custody and they're going away to a detox and a treatment facility where you can't go there. Sometimes you can drop off clothes to people. It varies. Generally, the court can help you with that and tell you, you'll find out where they're going for sure. But to find out what the rules are at that location, you can call there. Some courts have handouts from the facilities. But what I always say is, this mother or father was in crisis mode and was worried about losing their son or daughter, that they were going to die of an overdose. And I would say, you can go home and sleep tonight. That your loved one is safe tonight, and for the next at least 20 nights. So, and the hope is that this is going to work and that this is going to lead to further treatment and care. And again, we just have to have hope that it's going to help, folks. And I always say, if we can help one person, we have helped and we've done our job. And one person may be on a road to recovery. And that's why I do feel so strongly about what the court can do. And I don't think that people are aware of it. I think that people are, they don't want to come to court. They're afraid of the word warrant. So hopefully this has given you an understanding of what the court does do, and make you aware that there are these sections and petitions available if you ever need them. Thank you.
And thank you so much, Judge Kelley. We'll go ahead and open it up to the question and answer section now. I'm AJ McCormick, the executive assistant at SAFE, and I'll be the moderator for this portion. And we'll also have Jim, our director of family recovery, join in for answering some of these questions. So we're getting both the court side of it that Judge Kelley can present to us, but then also the family recovery side and how those go hand in hand, and how SAFE works with the courts and can help navigate these processes. So I think you're kind of ending on a note that was talking a little bit about barriers, and one I wanted to add on a little more. Could you talk about what kind of barriers someone could expect in terms of contacting their loved one, getting information about them after they have been committed, and what they should expect from after the point they file the petition?
Yes, that's a great point. So again, one of the hardest times is when you, as the petitioner, leave the courtroom and you know that your, again, I'm just going to say son or daughter is going to this facility that is, it's unknown. It's a place that we try to find a facility that's geographically close, but the most important thing is just finding a bed that's available for this person. So it's not a priority to make sure that it's close to where you live or where the court is. And most of the time you can drop off clothes, like that is, you can, their medication obviously is brought with them. Most of the time it's the police bring it to the court. They also get the medication, as long as there's a medication list, the facility can get that. And my understanding from talking with folks is that they can call. One of the problems that we have seen in helping people is their loved one calls and says, it's horrible here, get me out of here, I hate it here, I'm not getting any treatment, no one's helping me, no one's even coming to see me, and it's all bad, and they give specific examples. And then that person often comes back to the courthouse and says, I want to get this, I want to withdraw this petition. I want to get her home. I want to get him home. This is what's happening there. And that is challenging, because you can't, once you file the petition and the warrant issues, you cannot withdraw that until the person is brought before the court, or 5 days passes, because it expires after 5 days. So you can't say, I changed my mind if the warrant issued. Once the person is in lockup, we had a wife the other day who wanted to withdraw the petition when her son came to court. She saw him in lockup. She was upset, and she said, I don't want to go forward. So in that situation, you can say, I want to withdraw my petition, but you have to go before a judge, and only a judge can authorize the withdrawal of that petition. And a judge has to make a finding that there's no risk of physical harm to anyone if this petition is withdrawn and then the person is released from custody. Rarely is that going to happen. I'm just going to be honest with you. So most of the time, then the evaluation takes place, and if the commitment is ordered, so you can come to the court and you can say, I want him released. The court has no function in releasing that person. The only way that person can be released or moved is the superintendent of that facility does have the authority to transfer. This was a change in the law a few years ago. So the superintendent can transfer people to another facility. So you certainly can express your concerns to the facility and ask to connect with the superintendent or someone in the superintendent's office. That's the only way that your loved one can be moved to a different facility. These are not locked units, by the way. I just need to make sure that that's clear. So it's called an elopement, and we get notification in the courts when someone elopes, and it happens more often than you can imagine. So someone elopes and we get a notice, and what do? We go back in court and reissue the warrant for another 5 days. So, and then we find out where are they, and the family member will say, oh, they're at their girlfriend's house in such and such town. Here's the address, and that local police will act on the warrant. So it's not a prison setting. In any way, it's it certainly isn't. It isn't as nice as a private facility might be, but it is a place where your loved one is safe and getting care and detox initially, and then care and treatment.
AJ, before we go much further, I just thought, and Judge, I thought I'd comment that going through this process, I think you've already heard from Judge Kelley how extensive and how many rules and hurdles you have to get over and jump through, and hoops and forms you have to fill out in the court. And that can be an intimidating process. So I really want to encourage people not to do this alone. Please give us a call. It's safe. We can help walk you through the affidavit before you go into court, say the next morning. All these forms are available online. We can help you download those, fill out those forms. There are times that we can maybe even accompany you to court and help walk you through the process and walk you into the right doorways. So please don't do this alone, and please see us as a resource for this type of commitment action. Thanks.
That's great. And that was one question that Judge Kelley and I had discussed of intermediaries who can help out with this. And I'm not trying to just plug SAFE, but it's absolutely where organizations like SAFE can step in and be that support to help you figure out if it's time for this type of section, if there are voluntary resources that might be better fit, because it is something that is so difficult to manage on your own, and you're not alone, that there are resources like SAFE out there to help. So we do have a question from one of the attendees asking about Section 35, and that if a doctor is submitting the petition, are they required to go to the court? Is there reasons such as that, or other reasons that a doctor might be hesitant to file the petition for this person?
I can tell you that I rarely have seen a physician filing a Section 35. I don't see it too often. The petitioner does have to come to court. So they cannot, they have to appear in court. Now we could make an exception and have the person appear by Zoom. And it's the same standard regardless of who the petitioner is, what their standing is to the respondent. It's the same standard. They do have to come to court. They do have to fill out the petition and then the affidavit. They have to have personal knowledge. They have to have firsthand personal knowledge. When was the last time you saw this person? What's the evidence that they're using? What, have you seen needles? Have you seen bottles? Tell me why you're concerned so much that you want me to issue a warrant for their arrest? So sometimes the physician may not have the knowledge that a family member has, but it's not common, but we certainly, they're a party that can petition, and we would hear anything they have to say. And they cannot be the court clinician who's making the presentation before the judge. So that's a separate doctor that's going to do the evaluation after the person is apprehended.
AJ, we have a question here. I'm sorry to interrupt. We have a question here that I think I know where this is coming from, so maybe I can help decode it. We have had instances in which people complain because their loved one, Michelle, has been remanded under Section 12 to treatment, but leave 24 hours later. And so can you talk about why that might be?
Yeah, so that should not be happening. Are you talking about if they go to the hospital for a Section 12 and they're released? Okay, so yes, I can answer that. And that does happen all the time. So once a doctor orders a Section 12A in a hospital setting, so remember that the E comes from the court, but because of the federal regulations right now, that person is going to the hospital from the court. We don't have a mechanism to do a medical clearance to put them in a DMH facility. So they are always going to the hospital from the court. So their commitment may be through an E initially, but it's going to become an A. So once a doctor sections someone under a 12A, that is 3-day hold. That is, they are not released. They are in a locked facility. So the Section 12, they must be there for the 3 days unless a doctor releases them earlier than the 3 days. Only a doctor can release them earlier.
So
Now,
if someone was evaluated and it was deemed that they were well enough to leave,
yes, and
they could
it's shocking. We see it. We have sent people on Section 12s because we feel strongly that they need to be committed, and they get arrested that night. And we're saying, "How are you in custody? How did you get arrested? You were at the hospital yesterday at 3:00." And they go to the emergency room, they get evaluated, and the doctor determines that they do not meet the standard for a Section 12A commitment, and they are sent out the back door. Happens often. So that is something that is kind of out of our control. Once they're at the hospital, the doctor will do that separate 12A evaluation. And it's right now the 12E and the 12A is it's really not a comfortable setting, because if a 12E is done, it turns into a 12A. So it doesn't really have any teeth, if you will, where we don't have any authority. We don't have any mechanism to do a 12E and commit to a hospital. So our 12Es turn into 12As, which is an ambulance ride to the emergency room, and they're getting a separate 12A evaluation. And that doctor's determination stands. So that doctor may determine, if I don't find it, I don't see what I need to find to meet the standard for commitment.
It's very helpful.
Yeah.
You mentioned earlier co-occurring conditions. So someone may be experiencing substance use disorder and mental health disorder as well. How is the correct section chosen? What's the scenario like when that is occurring?
So if someone comes in and they say that their loved one is suffering from an alcohol or substance use disorder, and we're assisting them at the counter, we can't give advice, but we can listen to what's happening. And we will almost always, if we feel that there's evidence regarding, that there could be, imminent physical harm to them if they don't get care and treatment, we will always move towards the 35, because that is usually paramount. And again, that's a detox, initially a detox first, and then treatment. And they absolutely will get the mental health treatment through the 35 commitment. If they go by way of the Section 12, would they address the substance use or alcohol use issues? Yes, they would, but their focus in that hospital is going to be the mental health component. So I would always say but you have to make sure that they are suffering from alcohol or substance use disorder, because that's prong one. If the judge doesn't find that, there's no step two. So the warrant won't issue if there isn't enough evidence in the petition and the affidavit to establish that this person has I have the definition in my book when I'm on the bench. I keep it right there because I have to sometimes listen to the facts and say, okay, does this rise to the level of, you can drink it. You can drink until you're sick, and you can sit in your home and vomit and then go to sleep and get up the next day and drink and vomit and go to sleep. Like you can do that. And that may not qualify you for the imminent physical harm to yourself or others. If there's no evidence of health problems, again, if someone is driving is driving and they're drinking, that is an imminent risk of physical harm to others and themselves. So if they can't care for themselves, if they're not taking medications, if they have, medical problems that are, very concerning, that is a substantial, imminent risk of physical harm to themselves. So you have to kind of find these things when you're doing the petition and the commitment.
So switching a little more into kind of the family recovery and the recovery perspective. So a big part of recovery is the voluntary aspect, that it's time for yourself, and that's when recovery can really start to happen. But here we're talking about involuntary processes when we have to do it for the safety of someone else or others. So I think, Jim, maybe you can tag in some as well of how the family carries that and walks that line. But then also I'd like to kind of end it maybe on a hopeful note of what happens after the commitment, how the family can be supportive after the person comes out, especially because at that point you've or basically the bad guy or the person who's sent
That's
your
right.
loved one away?
Yeah, well, first of all, yeah, that's a great question. So, if the commitment is successful, and I'm talking now of Section 35, so we have up to 90 days. In reality, it's under 28 days, as Judge Kelley mentioned. There are a number of things a family can do. It's actually an opportune time for you to dig in, get your resources. First of all, take a deep breath, stabilize yourselves, find some resources, and start to get on your own path of finding resources for your loved one when they get out. So collaborating possibly in an aftercare plan for your loved one. Um, Equally as important to that, or more importantly for you, is to get yourself some help so that you can enter into your own recovery and extend that invitation to the rest of your family. And we can meet you and help you do that here at SAFE. But again, you've got 28 days now of sleep where you can actually get some rest, marshal your resources, start to get your own support, and even collaborate, possibly even with clinicians. Oftentimes, the clinicians will call you from the treatment settings, even under Section 35, and collaborate with you for aftercare planning. So it really is a great period of time to do all of those things. And then, moving forward, what you really want to do is stay in your own recovery. Acknowledge that, and this was hard, and I had to do it, acknowledge that we are powerless over whether or not our loved one has the willingness to want to stay sober or to get well or to take their medication, be compliant. Our powerlessness is really pretty much complete. I mean, we just don't have the ability to force them to do that. The one thing we can do is to work on ourselves, get into our own recovery, model that behavior for the rest of our family members so that they go out and get their own help. Again, whether it's peer support, support groups, clinical support, good self-care, massage, Reiki. There's a whole bunch of things that we can do to reclaim and recover some of that piece that is lost through the process of having somebody that you're supporting or loving that has either of these disorders. So it's a really good time to focus on yourself, and where we can help is help you separate a little bit from that fear, or learn to cope with the fear that your loved one is doing what they're supposed to be doing, so that you can focus on yourself and so that you can get back to the what I'll call normal conversations that a family has, supporting your other healthy family members with their activities, sporting events, and those types of things. So it's a really opportune time to do that. And the last thing that I'd like to say is that it was Michelle Kelley and then Clerk Magistrate Michelle Kelley that showed me that court officials have hearts, that they really care about outcomes. I could, if I had a nickel for every time Michelle Kelley pulled me into her office when she was clerk magistrate and I was in there filing a petition for my son, and gave me a glass of water and said, just calm down, take some deep breaths. You're not, we will see this through. And that wasn't because she knew me, because at the time she didn't. It was the way she treated everybody. She also introduced me to the judges at the time and made recommendations when I was appearing in other courts for judges that would have, I won't say sympathetic ears, but judges that had hearts that knew how to work with families. And they really are here to help us. And so I thank Michelle for that. It changed our lives. It changed the way we dealt with our son's illness and the way we dealt with the courts. And the courts were a big support for our family, and they can be for yours too. So thanks for letting me share that.
Yeah, thank you. And we are at a time. Any final closing remarks? Judge Kelley, would you like to say what's the single most important thing you'd want families to walk away knowing today at the end of this presentation?
Yeah, I would say, I mean, I do have to just say that, the courts can't give advice. So it's not the place to go for advice. And that is very hard, because people show up and they just want to tell us what's happening and let us tell them what to do. We can't do that. We can't do that. It's against the rules of our job. We cannot, as court workers, give advice. And that's always hard. So go to, again, folks on here know the SAFE Coalition. That's where you go. If the question is, is this the right thing for me to do? Should I be doing this today? I can't tell you that. I can't. we can't give you any advice. And also sometimes Jim, I appreciate what you said about, finding a friendly face, but sometimes you're not going to find a friendly face at your court because they're dealing with all kinds of cases, people in lockup. You are the one person who walked to their counter at that moment, but don't be discouraged by that. Don't be discouraged by that, and keep going forward with your petition. And again, like I love what Jim said, like call SAFE because they will help you. Someone at SAFE, I mean, I saw Jim numerous times just sitting in the audience next to someone, and other people at SAFE. So I think that SAFE is here for this exact purpose because it's not easy to come to court. So I guess one thing would be, don't be afraid to come to court, but know the reality of it. Don't think that it's all easy and fun and nice and friendly. That's not the way, it may not be that way in the court that you go to or any court on any given day, but the SAFE Coalition is there to help and has the resources to answer the questions that the court can't, and to guide you and again, sit right next to you if that's what you need.
And oftentimes, AJ, it's screening. We can help screen and talk to people about, the court is not there to judge whether or not somebody's struggling with addiction or not. They have to meet those standards, and the standards imminent harm. And so having a conversation with us ahead of time can really help people tease out whether or not they want to proceed with that process and maybe head in a different direction.
Yeah. And also one thing I didn't say, which is important, is that someone can come into the court and say that we've had people walk in by themselves and say, I need help. I'm an alcoholic. I need help. And I need treatment. Like I need help. And we'll generally have them talk to a probation officer. And that usually will lead to a probation officer filing the petition. Or they'll call a police officer to come in and file the petition. It varies in both courts, in every court. But and that person, by the way, the judge has to make a determination whether that person would create a security risk. So that person is not taken into custody. If someone voluntarily comes to the courthouse and says, "I need help," the judge makes a determination. Okay, ma'am, I don't have to issue a warrant because you are before the court. So I think we technically do still issue the warrant and, recognize the person's there and withdraw the warrant. But I can say to the person, I'm not going to put you in custody as someone normally would be. But I need you to stay in the courtroom and talk to your lawyer and talk to the clinician. And we'll just take this one step at a time, but don't leave the courthouse. You understand that? And if there's no evidence that I see or that's told to me for me to believe that this person would create a risk of harm or safety risk, they're not taken into custody. So that is, family members can come in with the person. It does happen. So that is another way to get the commitment.
And I know we're over time, but there's one more thing I wanted to address. There was a question that came in to me, and that was whether or not the police would, if somebody files a Section 35, whether or not it's successful, does that then put a mark on somebody for further investigation, more aggressive pullovers, that type of thing?
I'm going to tell you that is a no.
Right.
I'm telling you what my belief is after, as I said, many years in this court system. If a police officer is concerned enough about this person's well-being to come to the court, which again is not fast, they have to fill out the affidavit. Most of the time they're typing a report. They're concerned for your safety. They feel that you are at risk of physical harm.
And I think
they can't care for themselves in the community. That's what the police are seeing.
And that, I think that also stands, wouldn't you, Michelle, for people where the police officer is not filing, but a family member is filing. They're not out to target that person criminally or pulling them over for more aggressive investigations. This truly is a service.
Yeah. If anything, they have concern for that person, and they really feel that person needs help. And the last thing that they would want to do is pile on with criminal offenses. They often feel bad when someone is in custody under arrest. They will often say, I feel terrible. I've been working with her for the last 3 years, and we had no choice tonight. We had to arrest her. She did this. Unfortunately, as I said earlier, the untreated substance and alcohol use does lead often to some people facing crimes. But that's not always bad, because oftentimes probation does lead to recovery.
Yes.
And testing. And I just always caution families that if you can call the probation officer, but they're not going to tell you anything. You can tell them things, but that's their probation officer. And if they're violating their probation, you may have just gotten your, loved one a warrant. So you have to tread lightly when you're talking about criminal court, if it's not recovery court. There is a difference in the recovery court setting versus the general criminal court setting.
Well, we're with you. We want a recovery court in Rentham. So
yes, yeah, it's I think that I do think that there's a need for it. It's something that has to be established. There are significant steps for it, but I think it's something that, in having worked with SAFE for so long, I see the population that would benefit, and it really changes lives. It really does. Yeah. So thank you.
Thank you.
Jim, you want to close this out?
Yes, I want to thank again Honorable Michelle Kelley for being here tonight, giving so generously of her time. She is a foundational member of SAFE. She served long on our board until she got disqualified due to her judgeship. And but she's always a friend of ours. And once again, Michelle, thank you very, very much.
Thank you for everything that SAFE does, Jim and AJ, and so many people behind the scenes. So thank you. I see it. I see it when I'm in Rentham. It's incredible what you guys have done for our community. So thank you.
Thank you, Michelle. And thank you, AJ.
Yeah, thank you. Have a good night, all.
Great. Take care, everybody.